SJC-13364. Matthew Dunn v. Marie Langevin and others.
Okay, Attorney Rudolph.
Good morning, and may it please the court, Benjamin Rudolph on behalf of appellant Matthew Dunn. The issue in this case is not about the MCAD's authority or any policy or procedure of the MCAD. In fact, the MCAD's position on this case, as expressed in its amicus letter, which I encourage the court to consider and read, which was submitted a couple days ago and I believe is subject to a motion for late filing, is entirely consistent with my client's position. The MCAD relinquished jurisdiction over my client's claims intentionally in response to my client's request that it do so. And I would turn the court's attention to pages 84 through 86 of the record appendix in this case. Page 84 is the docket of the MCAD. It was provided in response to a public records request by the respondents, and it sets forth the timeline of what happened at the MCAD. What happened at the MCAD is that my client filed on November 16th of 2020. The complaint was docketed. It was reviewed for authorization. It was assigned to an investigator. And nothing else happened until April 1st of 2021, when we submitted a request using the MCAD's form, complying with the MCAD's procedure, saying we wish to file a Superior Court action under Section 9 of Chapter 151B, and the MCAD said, okay, go ahead and do that. And that was the end of the MCAD's jurisdiction over my client's claims. This case is very simply about whether the Superior Court should have applied this court's order, which did bind it, to toll a statute of limitations. Because, as this court said in
Which
Kadir,
statute of limitations?
well, as this court said in Kadir versus Stop and Shop, there are two statutes of limitations for purposes of Chapter 151B and employment discrimination claims. There's the statute of limitations at Section 5, which governs the initial filing of the complaint with the MCAD. And then there's the statute of
stop
limitations.
there. Did the SJC order toll that statute of limitations?
Very clearly so. The SJC order told all civil statutes of limitations.
How's that possible? It's an executive branch agency. I mean, forget what we called the COVID-19 order. Forget the name of it. Forget the supervision of the inferior courts. How is it that we can impact an executive agency's statute of limitation? Where does that power come from? I mean, not that the United States District Court and the Leslie University case is in any way dispositive, but where does that come from? How can we do that?
Because the agency doesn't own the statute of limitations. The root of the Superior Court's error in this case is that it didn't confront the question of for what purpose are we applying the statute of limitations?
We don't own the statute of limitations either. The legislature owns the statute of limitations. We can fool around with our own in the sense we can toll our own if the courts are closed, but we don't get to change the statute of limitations.
Well,
all we're doing is tolling what goes on in court, which we have power to do because the courts are shut. But the MCAD controls what the MCAD can do, doesn't it?
Yeah, I quite agree. Absolutely. And I'd quote from the MCAD's amicus letter. The MCAD's amicus letter sets this forth very nicely. They say, the Commission determines the timeliness of a Section 5 filing for the purpose of whether its administrative process is available to a complainant. And the court may independently determine the timeliness of a Section 5 filing for the purpose of whether a plaintiff may proceed with a civil action under Section 9. So the issue is, for what purpose are we applying Section 5? If we're at the MCAD controls. They're in charge, because the question there is, this is for purposes of an administrative proceeding, an investigation by the MCAD, a determination by the MCAD. When we're in Superior Court, however, under Section 9, then it's for the Superior Court to decide, because the purpose of Section 5 is merely to serve as a statute of limitations for a Section 9 claim.
Does it matter that the MCAD didn't make a determination as to whether or not they were going to allow it to go forward?
No, it does not, Your Honor. In Christa versus Edward Boyle, this court was very clear. The statutory scheme does not require that we have to have an agency action before you proceed with a Section 9 civil action. After 90 days, the plaintiff has an absolute right to withdraw a civil action, regardless of whether the MCAD has done anything.
But you have to file it. You have to file with the MCAD. Any complaint filed pursuant to Section 5 must be filed within 300 days. You don't file anything within 300 days, right? And then Section 9 is keyed it back into that, isn't it? Any person claiming to be aggrieved by a practice, blankety blank, may at the expiration of 90 days after the filing of the complaint with the commission. So these two things are tied together, right?
Absolutely so, and that's why it would be very problematic. The purpose that this court had in adopting the emergency order in response to the pandemic was to allow this extra time, because we knew that courts were closed.
But we can only mess with our own world. Otherwise, we're going to violate separation of powers. We're going to interfere with the legislature's rights to set statute of limitations, and we're going to interfere with the executive branch's rights to, do what they can do under the statute of limitations. We can't do that without getting into Article 30 problems, can we?
No, I quite agree, and we have never argued. The respondents absolutely want to make this case about we're trying to say that the SJC can tell the MCAD what to do. No way. You don't tell the MCAD what to do, and the MCAD does not tell the Superior Court what to do.
Are you arguing about something you don't need to argue about? I mean, isn't this really an equitable tolling case? You're not asking us really to extend the timeline for an MCAD filing. You're just saying, as a matter of equity, what you did in the SJC order was to toll it for purposes of Section 9.
Exactly right,
Okay.
Brenner. It's purely for a Section 9 lawsuit. I'm not at all arguing that the SJC order
But
applies
a
to the agency.
Section 9 lawsuit is contingent on a Section 5 filing. And the Section 5 filing is, we can't change the time deadline there, can we? The equity has to be exercised by the MCAD, doesn't it?
No, you can change the time for purposes of a Section 9 lawsuit only. So you can't change the time for purposes of an administrative proceeding. That's right, the MCAD controls that. But if the Superior Court's order in this case is allowed to stand, there are two extremely problematic things that are going to happen as a result. Number one, you're going to create a requirement that a complainant at the MCAD, if there's any possible issue with the statute of limitations, has to first obtain a decision from the MCAD, regardless of how long that takes. Maybe it takes 90 days, maybe it takes 120 days, maybe it takes 3 years. And they can't file a Section 9 lawsuit because they have to wait for the MCAD to make that decision.
I don't understand that at all. Why would that be the case?
Well, it certainly wouldn't, but that would be compelled by the Superior Court's decision here, because the Superior Court decided, look, the MCAD has total control over the Section 5 timeliness, even for purposes of Section 9 lawsuits. And the MCAD itself is not claiming that authority, as it says in its amicus letter.
No, there's a statutory prerequisite for the case to go forward in the Superior Court. So I agree with Justice Wedlin. Why don't you talk about Shaw's Supermarket and why you've got equitable tolling here? Because we just don't have the power under Article 30 to be ordering how long the statute of limitations is going to be for an executive agency.
Right, and I agree that what the order did was apply equitable tolling to civil statutes of limitations. And we know that Section 5 is a civil statute of limitations from 35 years of precedent in this court, in the First Circuit, and in the appeals court. It's repeatedly been called a statute of limitations. It's subject to equitable tolling. We know that already from several decisions of this court. It's subject to the minority tolling statute provision. And the analogous federal statute that applies to EEOC filings has also been held to be a statute of limitations. So when this court said we're applying equitable tolling to all civil statutes of limitations, and then in Shaws versus Melendez says, we meant it, all means all. There was absolutely no way for Mr. Dunn to understand that, oh no, actually there's an exception here. And when you file a Section 9 civil suit, all doesn't actually mean all. The equitable tolling clearly applied to this civil statute of limitations. We don't at all ask this court to limit the MCAD's authority whatsoever. I do want to address the gray core construction case because the respondents have built their argument around it. They absolutely depend on great court construction. And that case involved Chapter 254, Section 2, which is the mechanics lien statute. That section describes the mechanism for creation of a lien. It's not a statute of limitations and has never been called a statute of limitations. So it's entirely different from this situation. In great court construction, they were relying mostly on the argument about the language tolling deadlines in statutes. And this court very correctly said, well, we were talking about for purposes of civil actions, not for purposes of creating a lien at the registry or whatever you may be recording at the registry. Here, we're talking about a statute of limitations, and we're talking about applying it for purposes of a civil action in Superior Court, not for purposes of an administrative decision by the MCAD. Note that the MCAD, in its amicus letter to this court, does not ask the court to affirm the Superior Court's decision in this case. It does not ask for a particular outcome. It does not say whether the Superior Court's decision was correct or not. It says very clearly, we have our sphere of decision and authority, and that governs the administrative processing of complaints that are filed at Section 5 and stay at the MCAD. The courts decide what happens
In
once it's
connection
filed
with
in Superior
determining
Court.
whether equitable tolling should apply to your client, do we take into account the fact that your client failed to ask the MCAD through its own procedures to toll the 300 days?
No, I don't think so, because
Not, why wouldn't it be fair to consider whether or not your client bothered to do that?
for several reasons, Your Honor. First of all, it was docketed. The MCAD didn't give any indication, any order or anything saying, hey, this is late. Secondly, because we know under Christo versus Edward Boyle, we don't have to have an administrative decision of any kind prior to
You don't
filing
have to have
Section
an
9.
administrative decision, but it's clear that that goes first. And it's clear that it's within 300 days, and the MCAD has now provided for a procedure, its own executive branch agency procedure, to file something late. Why isn't it fair to consider whether or not your client bothered to go through that procedure in determining whether equity requires us to toll?
Well, for one thing, Your Honor, the record does not say when that procedure was established or when it was communicated to the public.
And whose burden is that?
It's the burden of the respondents to demonstrate that, because if they're the ones saying, well, you had to comply with this procedure that you previously didn't know about, that none of the precedent told you had to engage in. And
Well, now you're explaining why you didn't do it, which may be fair.
we had no indication that we had to, Your Honor. There was absolutely no indication that we should. We filed the MCAD complaint. We communicated with the MCAD saying we would like to withdraw, and this is 4.5 months after the complaint was filed. So the MCAD in its letter expresses concern about we need to have the opportunity. We need to have time. That's why we have a 90-day period in Section 9. We've got to have time to administratively decide, do we want to investigate this complaint ourselves? Well, there was 4.5 months for the MCAD to do that, and they didn't do anything, and they didn't dismiss the case because it was untimely or give any indication that it was untimely. And when we asked explicitly, please relinquish your jurisdiction over this case so that we can proceed to Superior Court, the MCAD said, granted.
But you said that you didn't know you had to do something special, but you did know what the period of time was within which you had to file the MCAD claim.
Well, we always planned to file in Superior Court under Section 9, and we knew that the order from this court said that those statute of limitations are tolled equitably. We knew from 35 years of precedent that Section 5 is a statute of limitations. So the plain language of the court's order and the statute itself, which, by the way, in its title refers to limitations, makes it very clear that it's a statute of limitations. And by the way,
But they're gonna stand up and say, you should have known that Section 5 wouldn't be told. It's a court order. It has to do with courts. What's your response that Shaw's really can't be interpreted as impacting Section 5?
because if we know Section 5 is a statute of limitations, and the plain language of the court's order says all civil statutes of limitations are subject to equitable tolling, how are we supposed to infer some sort of exception for purposes of a Superior Court case. And the respondents will admit, they have to, that it is a statute of limitations. In their brief, they cite to Charlin versus Musi Motors, which said, yes, it's a statute of limitations. Under the plain reading of the orders and all of the case law, how could we have known, oh, no, actually, it's not a statute of limitations, or it's somehow subject to some
You
sort of
gotta dig
exception?
into what Shaw's holds in the period of time from March 17th to June 30th and what was being analyzed.
Well, under Shaw's, it describes what is a statute of limitations, and consistent with the description in Shaw's, this is absolutely a statute of limitations, just like the court has said for 35 years.
What weight should we give MCAD's statement regarding extension guidelines on its website? When did that come up, and when shouldn't that have not been a factor in this consideration?
The record doesn't say, and so I can't answer that part of it, but I think the court should, again, look at the MCAD's amicus letter, because I think the MCAD's amicus letter eloquently explains how there's this separation of powers. The MCAD decides Section 5 deadlines for MCAD cases that are being administratively determined. The court decides for purposes of Section 9 lawsuits. And that preserves the separation of powers, and therefore the courts aren't overstepping their bounds, and the MCAD is not overstepping its authority either.
So is equitable tolling done on an individual case-by-case basis in your estimation? Or is it that the SJC order created this wide swath of MCAD stalls?
Both, Your Honor. We argue that the equitable tolling set forth in the court's order definitely applied to Section 5 for purposes of Section 9 lawsuits.
All right, let's say we disagree with you.
Well, then we have our argument that under the circumstances where Mr. Dunn could not possibly have known, could not have anticipated the outcome of this case, saying, notwithstanding the plain language of the court's order, notwithstanding all of the precedent saying Section 5 is a statute of limitations, notwithstanding the MCAD voluntarily relinquishing jurisdiction and saying nothing about the timeliness, you should have, at the MCAD, said, I'm filing a motion, I want this to be determined at the MCAD, wait however long it takes, maybe months, maybe years, for a decision on the timeliness, and only then file in the Superior Court.
What
That
about
couldn't have been
what about
anticipated.
254-2B? Why isn't that a statute of limitations in the Gray Court case? The deadline for recording the notice of contract is the earliest of 60 days after the filing or recording of the notice of substantial completion, or 90 days after. We don't, under your theory, every statute of limitations is extended. Why wouldn't we decide Gray Court the opposite way?
No, that's not a statute of limitations.
Why
Your
is it?
Honor.
It's exactly, it's a time deadline for filing something in the,
In the Registry of Deeds to create a mechanics lien, but not, it doesn't have any direct connection to a lawsuit.
yes, it does.
It's only a prerequisite to filing a lawsuit.
the
and-
same way that the Section 5 filing is a prerequisite to the Section 9 filing, isn't it?
I respectfully disagree, Your
Why
Honor.
not?
Yeah.
Tell me why that isn't a time deadline in a statute, and under your theory that every time deadline is extended by our order.
No, Your Honor, I'm not saying every time deadline. I'm saying every statute of limitations, and that's
Statute-
separate language in the order.
That's a statute of limitations the same way Section 5 is a statute of limitations.
It has never been held to be a statute of limitations, Your Honor.
But Section 5 doesn't refer to itself as a statute of limitations.
It does in the title. It says limitations in the title, and this court has repeatedly said it is a statute of limitations, unlike with Chapter 254, Section 2. I would add,
But even past the labeling, we said in Gray Court that that the orders only apply to court operations. That was the crux of where we came out on Gray Court. So how does this? How does this, again, aside from the labeling issue, you still have the prerequisite, and the prerequisite has to do with an executive agency that we do not control.
well, as Your Honor wrote in Gray Court, it applies to deadlines that apply to matters pending in court or to be filed in court. Section 2 of Chapter 254 does not anticipate necessarily that there's going to be any filing in court. It's a prerequisite to the enforcement action only in the same way that having a valid contract is a prerequisite to filing a breach of contract claim. If you don't have a valid lien, then you can't file to enforce it. And that's what happened in Gray Corps. They didn't have a valid lien. But that's entirely different from a statute of limitations.
But you don't have a valid lien within a certain period. You have to comply with these time deadlines in 254-2, right?
Right, and if you don't, then you don't have a valid lien. But that's not the same thing as a deadline for filing a civil action.
If you don't file a Section 5 claim, you don't have a Section 9 claim, because for 90 days, we want the MCAD to have exclusive jurisdiction over these things, right? I mean, I'm having trouble just understanding why it's different.
Well, for one thing, Your Honor, and maybe this is helpful, in Chapter 254, Section 2, when you record the notice of contract, the registry's got to record it. It's got to docket it, essentially. And then there's actually a second step that you have to take. You have to record a statement of account after that. And those two things happen before there's any consideration of whether you're going to file a complaint.
But in Section 9, in your world, you can't bring your Section 9 claim until you've shown you've brought a Section 5 claim. And we've thrown out a bunch of, you don't just get to skip the MCAD. We want you to go there because things go away there.
And we did not skip the MCAD. We filed a complaint, it was docketed, and then we complied with the MCAD's procedure to request withdrawal.
Not within the time deadlines.
Well, within the time deadlines, if we were at the MCAD, and I don't know if, I know I'm well over my
I think
time.
you're being signaled, I'm to stop.
All right, well, I thank you very much for your consideration of this important case, and I will rest on my briefs.
Thank you. Okay, Attorney Conti.
Good morning. I'd like to start with the mechanics lien statute. Counsel said it has no direct connection to a lawsuit. It absolutely does. The mechanics lien process is you record a notice of contract at the Registry of Deeds, an executive agency. Thereafter, you have to record a statement of account.
So let's say we agree with you that Article 30 would preclude us in the judicial branch from tolling a statute of limitations that applies to the executive branch. Let's assume that for purposes of this question. Why doesn't Christo allow us to independently, equitably toll that 300 days? Because under Christo, as I understand it, it said, hey, there's two routes here. They're largely independent. And so, dear Superior Court justices doing discrimination cases, you decide independently whether this particular case should be equitably tolled, regardless of whether or not the MCAD did so.
Your Honor, so in the Gray Corps case, a lawsuit was eventually filed to perfect the mechanics lien. And what the court found is that the notice of contract was not timely because the COVID rules did not apply. And as such, it was the mechanics lien for $3.4 million was not timely. Here, what you have is you have the plaintiff, now you're asserting equitable tolling or potentially under Christo, but this is a very different situation. They never sought relief from the MCAD. The MCAD for the first 90 days has exclusive jurisdiction over the matter. There's no case or controversy at the MCAD when the plaintiff dismisses his complaint and goes to the Superior Court. In Christo, the issue was the investigator had made a determination and there was no review process in place. And that's where the court found that the Superior Court should have the opportunity to review the underlying decision. That was the basis.
Was it review or was it make an independent assessment of whether or not it should be equitably tolled?
They never, the point is in this case, The plaintiff never asked.
Yeah, so we don't actually have a conflict between what the executive branch has decided and what the Superior Court might decide. Instead, we have an executive branch not deciding anything, and the Superior Court can decide whether or not to equitably toll. It seems to me that that presents less of an Article 30 problem than Christo did, where there could be directly opposite conclusions.
I think you have two problems with that. One is you don't have a case or controversy because they dismissed the case from the MCAD.
But the case or controversy rises or falls on whether or not there's discrimination. I don't know what you're talking about in terms of case or controversy.
So the MCAD, the issue is they never exhausted the administrative remedy. They never went to the MCAD and asked for an extension of time.
And doesn't Christo tell us that you don't have to exhaust administrative remedies?
They absolutely had an obligation to go to the MCAD and ask for an extension of time with respect to the filing because the SJC COVID order did not apply to the executive agency. They didn't do that. When they didn't do that, there's no case. They didn't exhaust that's distinguishable from the facts in Christo.
And so I guess going back to the facts, in the record, what is supporting the proposition that the MCAD's process for extending the 300-day deadline was in place at the time that this particular plaintiff filed its MCAD complaint?
I can get you the citation, Your Honor, but there's a case that's been cited that was in the MCAD that we've cited that includes the MCAD granting an extension of time. And my understanding is that the extension process has been on their website all along. That has been the case.
But when?
And it's case by case.
When you mean all along? I mean, it's important.
From the
I think,
inception of the
March
COVID
17th?
orders.
March 17th? And just stuff in the record. I don't want anything that's non-record.
This is record, Your Honor. We're going to get you the citation. It's in the case of Anthony Toto v. Lowe's Home Centers, and it's dated 15 October 2020.
Also, Christo is there's some issue about whether the agency affirmatively misled, right? That's one of the reasons
Yes,
the
Your
court sort of fools around with the equitable tolling of the agency in Christo because there's sort of affirmative misconduct on the part of the investigating commissioner?
Well, yes, Your Honor. And not only that, as distinguished from our case, Mr. Dunn was represented by competent counsel throughout this matter. There's been no allegation of misrepresentation or being misled. In fact, at the lower court level, in the Superior Court before Judge Kenton Walker, plaintiff didn't even argue for equitable tolling. Judge Kenton Walker raised it sua sponte and took those issues on and found that the plaintiff had not been excusably ignorant, which is the standard.
Would that change, though, if even with a reasonably prudent lawyer, they just misread our order and thought that, for all of these years, we looked at Section 5 and said that they were statutes of limitations and interpreted that way, and that the council just assumed that this was a statute of limitations that was told by by our orders?
Yes, Your Honor, and it goes to your superintendent's powers as well, and it would also, to reach in now, would violate the doctrine of constitutional avoidance in this instance by interfering with the rulemaking authority of an executive agency such as the MCAD.
But the MCAD didn't rule on this at all. So why should we assume that they wouldn't have given them, extra time if they had asked? And the fact that they sort of just said, okay, we're gonna let this go on, instead of saying, no, you didn't do it right, can't we assume that that means that, okay, we're gonna let this go ahead?
Your Honor, I don't think you can, because the process is the MCAD, you have a 300-day deadline. It's a prerequisite to the filing. It's a prerequisite to the filing, but also a prerequisite to, after 90 days, dismissing and moving to Superior Court.
But because of the pandemic, they instituted a rule saying that we'd look at it on a case-by-case basis.
Yes, and the problem is, would the I think your question is, would the MCAD have granted the extension of time? I don't know the answer to that, but based on other matters I've looked at, they probably would have, in all candor.
And do they implicitly do that by, they don't say you missed our statute of limitations, right? They just dismiss it. Is that sort of an implicit grant of the extension?
Unfortunately for the plaintiff, no, it's not. And the reason it's not.
And why not? Because,
Well, it's just like, Your Honor, analogous to if you had filed in a court and you missed the statute of limitation. The plaintiff, what's not analogous is in this instance, so the
well,
MCAD.
but they, you know, their letter says they have the power, they have control. They don't, I assume they have a standard letter saying, you missed our 300 days or whatever, or do they not have such a thing?
Not to my knowledge, Your Honor. And the issue here is, after 90 days, it was the plaintiff that decided to dismiss the action. If the plaintiff had left the matter in the MCAD and later sought relief, he may have been granted it. But they didn't do that. The plaintiff terminated this. The MCAD terminated the action at the request of the plaintiff after 90 days. But the MCAD had exclusive jurisdiction for that 90 days. So it could have decided to take the matter in 90 days and decide it.
But he waits like 130 days. He leaves it with you longer than 90 days, right? The plaintiff leaves this with you for more than 90 days.
He did, Your Honor, I believe.
He leaves it with the MCAD for more than 90 days. The MCAD, then he does what they always do, which is go to court, because that's where the money is. And they dismiss it. It's just hard to figure out what the MCAD actually did here.
If I may, Your Honor, I don't know for certain, but it appears they docketed the matter like they normally do. But the
Do you have a standard practice when they say you missed the deadline?
Not to my knowledge, Your Honor.
But your point is that the Section 5 is a prerequisite to filing, and as far as Article 30 goes, there's issues there. But on the equitable tolling, isn't it reasonable for an attorney to read all statute of limitations means all statute of limitations, and there's a footnote 3 that goes through all the different implications that come into that? And so, assuming you're 100% right on the first issue, why isn't all means all enough for equitable tolling?
Yeah, I mean, first, but for the grace of God, go I. The issue is, the problem with that is that I don't think it's analogous to the mechanics lien situation. It was the notice of contract was a statutory prerequisite. Without it, you're out. And the equitable.
Well, without it, you don't create a new right. I mean, that's the problem I think you have with the Gray Corps analogy is that, you know, in Gray Corps, there was this lien and a perfection of the lien that all happens, and then that gets enforced in court. Whereas here, you know, you talk about case or controversy, the case existed at the time the discrimination happened, or the alleged discrimination happened. The 300-day period is just for the MCAD to go through its process, and then you wait 90 days. You're not creating a new right at the MCAD.
But, Your Honor, you have to consider the Superior Court lawsuit was filed within the 300-day period. And when the Superior Court lawsuit was filed, they still had an additional 45 days at least in which to file timely in the MCAD, and did not. That's not indicative of a case for equitable tolling. It's just not. Your Honor, to answer your question, Addendum 50 is the record citation.
Thank you.